welcome to everyone to this webinar on behalf of the Digital Trade Alliance. I'd like to welcome you all to this timely webinar about what we know so far about the US-Kenya Strategic Trade and Investment Partnership and its potential implications for digital rights and online privacy in Kenya and throughout the African continent. The Digital Trade Alliance is a cooperative effort of digital rights and consumer groups from the Global South and Global North that's come together to share ideas, collaborate, and produce needed research to inform the debate on the intersection of digital rights and digital trade issues. My name is Melinda St. Louis, and I am the Director of Public Citizens Global Trade Watch based in Washington, D.C. And we help to coordinate the Digital Trade Alliance. And I'll be providing some context from the US side and moderating today's discussion with two prominent experts from Kenya. We're proud to have with us today Dr. Melissa Omino, the Acting Director of another Digital Trade Alliance member, the Center for Intellectual Property and Information Technology, based in Nairobi, and Dr. Paul Ogenda from the Faculty of Law at the University of Nairobi. So to begin, negotiations for the US-Kenya Strategic Trade and Investment Partnership, or STIP, or STIP, as we may call it during this webinar, have just begun in earnest, with the first round of conceptual negotiations just concluded in February. This initiative lives in the shadow of the Trump-initiated US-Kenya Free Trade Agreement negotiations, which the Biden administration initially shelved over misalignment with the previous negotiations' priorities and ambitions, and to review the compatibility with Biden's stated Build Back Better agenda. But then last year, the administration announced that it would initiate these US-Kenya STIP talks, requested public comments to provide direction. Public Citizen and a number of organizations, but many more corporations responded to that call for public comments. And then no more information was provided about next steps until the recent round of negotiations were publicly announced just immediately before the talks happened in DC in February. So far, there have been few details of exactly what the Kenya STIP will be, but the administration has stated explicitly that it will not be a traditional free trade agreement and that it will not include market access commitments. It appears to be following the approach the administration is taking with a patchwork of other negotiations in other parts of the world. The most advanced of these is the Indo-Pacific Economic Framework, or IPEF, and the US Trade Representative, Catherine Tai, has stated repeatedly that the Biden administration's vision for trade will not repeat the past mistakes of prioritizing efficiency above all else, but it will serve workers, consumers, and the environment. This is a welcome change after decades of US trade policies that privileged large business interests, leading to job offshoring to countries with exploitative labor conditions, encouraging of polluting industries, and constraints on domestic policymaking to protect consumers. But it remains to be seen whether these stated goals will be realized in the US-Kenya STIP or other agreements, because thus far there's very little information that has been made available about the plans and the details of what will be discussed in the STIP. There are clearly many potential implications for a whole host of policy areas, but today we'll focus on the digital sphere. As the US administration has noted, that digital trade will be an important element of each of these new frameworks and partnerships, including the US-Kenya STIP. Digital rights advocates and experts have serious concerns about the model for digital trade rules that were included in the US-Mexico-Canada agreement that was negotiated under the Trump administration, and those rules' implications for domestic policymaking to protect consumers' data online and to hold large digital platforms accountable for discriminatory or anti-competitive behavior. These provisions created binding commitments that require the countries to conform all their laws, administrative procedures, and other government actions to the obligations of the agreement. And that can tie governments' hands with respect to what policies they can take domestically in the technology sphere. And this is really important right now when regulators around the world are struggling to keep up with the technology, to figure out how to best protect consumers and the public, given the emerging technologies. We have yet to see the Biden administration's proposals in this area, but we do know that the US government produced a draft digital trade chapter for the Indo-Pacific Economic Framework negotiations that has been submitted to other parties, where it will be discussed in an upcoming negotiation round in Indonesia next week. Those texts are classified, so the public can't see the details yet. Only cleared trade advisors have access to those texts, nearly all of whom in the trade advisory committees represent large corporate interests. It seems quite likely that the model for digital trade for IPEF will be quite similar to the text that the US will propose for the US-Kenya STIP. And we understand that the next round of negotiations for the Kenya talks may happen in April, and that will include text-based negotiations, as we've heard from the chief negotiator. So it'll be important to watch what happens with these texts. If the administration replicates the US-Mexico-Canada agreement digital trade provisions in the IPEF or the Kenya STIP, which is what we know that big tech companies are pushing for in this deal. There are policies in Kenya and laws being proposed in the United States that would be in conflict with such blinding digital trade commitments. Legislators in the US are becoming more concerned about the implications of these provisions, and I imagine those in Kenya will be as well. So to tackle some of these questions, we're honored to have with us, as I mentioned, Dr. Melissa Omino and Dr. Paul Ogendi. Dr. Melissa Omino is an intellectual property expert with a research focus on development and negotiation of IP provisions in international trade agreements by and with Global South countries. A cum laude graduate with practical legal experience both in academia and practice, Dr. Omino holds a doctorate in law, focusing on intellectual property and trade law. Her range of expertise also includes legal frameworks within the sphere of artificial intelligence, data protection, and digital rights. She also focuses her energy in mentoring and nurturing researchers as part of her role as acting director at the Center for Intellectual Property and Information Technology, or CIPIT, where she leads projects in IP and data protection. Dr. Omino is an advocate of the High Court of Kenya and is also a co-host of the Friendly Troll podcast, where she disseminates research to a wider audience in the Global South in accessible language. Dr. Omino has produced policy briefs commissioned by the Digital Trade Alliance for around the US-Kenya STIP, and we're really grateful that you're here. And secondly, we have Dr. Paul Ogendi, who's a trade expert and researcher at the Faculty of Law at the University of Nairobi at the Kisumu campus. He is also an honorary research fellow at the University of KwaZulu-Natal in Durban, South Africa. His research interests are in human rights, medical law, intellectual property, trade, competition law, commercial law, genomic research, and data protection law. His LLD thesis topic was on pharmaceutical trade policies and access to medicines in Kenya, and his previous professional experience includes at the following institutions: Boston University Global Development Policy Center, African Commission on Human and People's Rights, the African Court on Human and People's Rights, Institute for International and Comparative Law in Africa, the United States International University in Africa, the AIDS Law Project, and Kelleen. So welcome, and thanks to both of you for being here with us to dig into some of these questions. So to begin with, can you share, both of you, share from your perspective and from the Kenyan perspective, more of the context of what the US-Kenya STIP is, particularly coming out of the US-Kenya free trade agreement negotiations?
Thank you so much. I'll go first, and I hope that because you've mentioned that I am a host of a podcast, that people will not be afraid of my mic, and I hope you can hear me and see me clearly. I hope you can hear me. You can?
Yes.
Excellent.
Yes, we can hear you.
Excellent. So the context for the US-Kenya STIP really falls within the background of the US-Kenya FTA, although the sentiment is that these are two separate agreements. These bilateral free trade agreements between the government of Kenya and the government of the US really came about from the previous Kenyan government, because we have had an election and there's been a change of government that happened last year. This really brings in the context of what Kenya can bring to the bargaining table, if anything, with regards to trade between itself and the US. That is the main context for it. Now, in the context of digital trade, it's actually a new frontier for Kenya to be negotiating in, and actually for any country within the region or on the continent. We are aware that the African Continental Free Trade Agreement has a digital trade protocol, but that is also the first of its kind on the continent, and we're not really sure yet what that would contain. So the context for this is Kenya has been a leader in trade within the East African region, but also it has been leading in terms of innovation such as M-Pesa, and looking at other innovations such as artificial intelligence and the digital trade landscape, innovations that would help facilitate the digital trade landscape. So entering into an agreement like this has great ramifications. There's also the context of the legal framework that currently exists in Kenya. We do have a Data Protection Act that came into place in 2019, and that governs personal data of Kenya's citizens, and also governs things such as cross-border data flows. So that means data moving from one country to another, and specifically data moving from Kenya outside of the borders of Kenya. So everything sounds really new and interesting, but it's a timely agreement. But I think the red flags or things that we are concerned about really rotate also within this context of negotiating with a giant such as the US in novel areas. Doesn't really have a good track record for developing or least developed countries, because we do not have enough bargaining power, and B, we are usually looking towards technology transfer or knowledge transfer into the developing or least developed country. So that's the context that really sort of grounds this agreement, and leaves us to ask further questions, which we will discuss later.
Thank you. Can I go? Yes. Now, I want to take a different approach and underscore the context, not just from the US-Kenya free trade agreement under Trump that was put on hold, but also the fact that the AGOA framework has always been something which nobody's sure will continue. So you find the Kenyan government jittery to continue its access to the market, which is provided under AGOA. So there's need for a framework to manage trade beyond AGOA. Number two, if you look at the experience with EPAs, which is Economic Partnership Agreement that was being negotiated, there was a realization that the community, the East African community, was not moving together. And therefore you had Kenya and Rwanda signing the EPAs, but other members of the community did not be part of this. So you have a very fragmented community in terms of free trade agreements. And then you have a country, which is not a least developed country, relying on a very important instrument in the US, which they are not sure will be extended. So they want something, a framework, to be able to prepare itself for what comes in the future. Now for US, of course, there's that need of building back better. I don't know if it's a COVID context, because that has always been the mantra. But I think looking at why the discussion has moved from intellectual property and access to medicine, which is many pharmaceutical company and their needs in different sectors of the Kenyan or developing countries, particularly IP protection, to now digital rights. It shows how important the economy, digital rights economy is for US. And I was just looking at the top 5 companies. They're all dependent on data and digital trade, which now makes them the golden boy of the American government. And just the way the American government supported the pharmaceutical companies, we can see the same support now being extended to the digital rights trade sector. And now also, just to mention, there's also another free trade agreement being negotiated between UK and India, where the issues of intellectual property are taking center stage. So we see the context is that different countries are pushing for their own agenda. I'm not sure what Kenya will be pushing for, but let's find out.
Thank you for that introduction. I'd like to dig in a little bit around since we're talking about the digital rights landscape. Dr. Omino, as part of the Digital Trade Alliance Commission, you and colleagues spent a fair amount of time analyzing the comments from big tech corporations and their trade associations about the desires for the Kenya STIP. And it's quite instructive, I think, to look at these comments from US industry because, as I mentioned previously, corporations have historically had an outsized influence in US government position in trade negotiations. When only the 500 corporate advisors have access to the text while the public's locked out, their interests have tended to be reflected. And so if you could highlight some of the industry comments that you noticed and potential conflicts between Kenya's data protection laws and provisions in the agreement.
Yes, I can. Thank you. Yes, so the first thing I'd like to say is that because free trade agreements are normally negotiated in secret, it's really difficult to tell what the final text would look like, as you've rightly said. But it's usually a good indication to look at what industry is saying, because we do know that industry lobbies to get their interests into these types of agreements. And it's usually skewed towards the US side because they do have a consistent process of public participation through the soliciting of comments from industry. And so that's why we looked at the comments, which are publicly available, to sort of see what could end up in the STIP. We're not saying that this is in the STIP, but we're saying what could end up there. And it was interesting to note who exactly was commenting and what they were saying. So most of the comments were from what I would call big tech. There was also comments from big pharma, and there were comments from trade lobby groups, for example, the American Chamber of Commerce in Kenya and other associations of different industries as well. And most of these industries really pushed for their own interests. That was quite clear. So a good example would be to look at data localization. Data localization is where you are asked to sort of have industry for data processing within the country where the data has been extracted from. And we do have this provision of data localization within the Kenya Data Protection Act. Interestingly, this came up in quite a majority of comments from what I would call big tech. And their request was that any obligation towards data localization should not be allowed or should be prohibited via the STIP. They do not want to have the obligation to set up data centers within the Kenyan space. On the other hand, while the Data Protection Act was being launched in Kenya, one of the benefits of that act was that it would boost innovation in Kenya and would boost industry to sort of have these data centers set up. So that's a good example of direct conflict showing up between the desires of industry in the US and legislation here in Kenya. Similarly, there were comments that talked about elements of privacy and elements of protection of personal data. And these privacy or elements of personal data specifically, or sensitive personal data, are really what is mined or used by industry. And Kenya has an act that protects or prohibits the transfer of this type of data, and also has certain conditions under which this would happen or allow that to happen. Most of these comments asked for that not to be allowed via the STIP, rather to ask for such prohibitions not to be there. So it was an interesting juxtaposition because they do say that they are for privacy, but the limit or the barrier between them upholding privacy of Kenyan citizens or citizens in general from both sides is that privacy should not be a barrier to trade. So that already tells us that they are weighing more towards what would allow free flow of data for the purpose of trade. The conflict there with Kenya is that the Data Protection Act is really grounded under the Constitution or in the Constitution, where the right to privacy is within the Constitution. So even though we know that human rights can be balanced with each other, it's really interesting to see how the Kenyan side will counter that, because this means that Kenya's laws could really be invalidated by this agreement. And there would need to be a change or an upgrade or sort of a meeting of the minds between legislation in Kenya and legislation in the US when it comes to data protection. Something else that is interesting is that we know that there is no intellectual property chapter, or there will not be an intellectual property chapter within this STIP. But there are elements of intellectual property that do come up, or surrounding innovation. So for example, the call for protection of source code in artificial intelligence. Now, depending on where you fall within the intellectual property sphere, you could look at source code as copyright, or you could look at source code as a patent. It doesn't matter. That's not the argument here today. The argument is how that should be protected, and in the context of the data that this artificial intelligence algorithm is using. So in Europe, there has been the argument that source code should be open so as to allow consumer protection groups or regulatory bodies to see exactly what type of data is being used or processed by the algorithm. And this allows them to protect citizens' rights. But many of the comments called for protection of the source code in these artificial intelligence algorithms because of business interests. And if you cannot see the source code, you cannot tell what type of data is being mined, and that is really a red flag. So all these point toward one thing: the best interests of US industry. There were very few comments that really talked about ensuring that Kenya still had policy space to make its own decisions about certain areas. Very few comments that really talked about a meeting of the minds. Many of the comments asked for similar or even identical provisions, such as those found in the USMCA, which I've already mentioned, and even the US-Japan FTA. So that already tells us that we can look at those texts to sort of predict what will be in the US STIP. And we're talking about completely different economies and completely different things that drive these two different economies. And as Dr. Ogendi really said, Kenya's focus will rightly be on traditional areas of trade, such as agriculture, horticulture, manufacturing. And I'm not quite sure if we are thinking about what will be in the digital trade chapter, or even what will be in the regulatory practice chapter.
Thank you. Thank you. That's really helpful. And as I mentioned, these are concerns on the US side, as well as the United States, Congress and the administration have been grappling with these issues and how to best regulate big tech to lock in binding commitments that would restrict that ability is also a concern in the US. And so I think, and it's interesting to hear that is potentially, a big concern in Kenya as well. So thank you so much for sharing that. And I put in the chat a link to Dr. Omino's research, an analysis of those comments that can be found on their really excellent website. So Dr. Ogendi, could you jump in and share what the Kenyan government's process has been for approaching trade agreements like the STIP? I think that is also important in terms of kind of how the public is involved, how legislators are involved, et cetera, as we kind of build potentially a new model for trade negotiations, or do we expect that it will be kind of similar to the past?
Yeah, so thank you very much. That's a very important question. From the experience in previous negotiations, the leader of this particular talks usually come from the Ministry of Trade. But the way they operate is that because of the areas which are going to be negotiated, they usually form committees trying to bring on board different other ministries and departments of government which are concerned and therefore they form sectoral committees which are going to look at the different sectors or thematic areas which are going to be negotiated. And based on that, they can agree on a consensus, and then the leader will be able to present this during negotiations. So that is how they have been operating. The only problem I have with that approach is it is paternalistic in that the big guys are the only ones invited to participate. And they always assume that the people or civil society do not have any input, or they are only there to disrupt. It usually brings a lot of conflict, because what you'll see in the coming months is a lot of statements and analysis from civil societies and research institutions, because they don't simply have any seat at the table. And even if they're invited, it's usually like in a few days ago, the US side at least made an effort to listen to Kenyan issues with the Kenyan government itself. And that is a major concern because trade is not an elitist agenda. As far as I'm concerned, if the US wants to pursue the interest of its big tech, and they're very serious about their participation, the Kenyan government at least should listen to agriculturalists, because that's what they would be pursuing, or even the general public. So there's need for Kenyan government to understand that trade is just another topic. It is not for the elitist alone. And everybody has something to say about the process. So to keep it secret for whatever reason can be strategic, but it doesn't yield the results the Constitution of Kenya requires. It says public participation is a right, and not involving the public, even just by asking them to write memoranda at the beginning, so that you're able to use the memoranda to define the agenda. You're not giving the text to stakeholders to comment on, but you want to pick the ideas from everyone, so that me coming from the pharmaceutical sector, I'm able to say what exactly is happening. Somebody from agriculture is able to also say what they think should be covered under that. So that is the approach that should happen, but unfortunately, that has not happened. So we hope that this time around, if the Biden administration is serious about protecting consumers and workers' rights, like you say, we are the consumer, the public is the consumers. So they must ensure that not just the supply side is taken care of, those who are supplying products or whatever it is, but the consumers themselves find their voice and a seat on the table. And just to comment on the issue of privacy, the Data Protection Act is a privacy instrument. It protects the right to privacy as we enshrine in the Constitution. So those standards, I'm not sure whether can be derogated through a trade agreement. It's like you're saying you can actually violate human rights using a trade instrument. So the government should be very serious about this kind of approach, because there's nothing which is much more superior or much more higher in standard than the Constitution of the Republic of Kenya. Thank you.
Thank you so much for that. Next, Dr. Omino, you shared with me that just this week, the Africa group at the World Trade Organization submitted a statement about how multilateral agreements and in the trade space can erode policy space. And I think that's part of what we're discussing here, making sure that there is sufficient policy space for, for regulation of big techs. And so can you share some concerns about, how this, how a Kenya STIP or similar negotiation could impact respect to domestic policy around digital rights in Kenya?
Okay, thank you. Yes, so I think if you look at it in the context of the Africa Group statement that was released earlier this week, it really tells us that there is, even in the multilateral system, which is basically what the WTO represents, that there is still a battle between least developed and developing countries and developed countries when it comes to maintaining policy space. I definitely understand that there is a need to sort of align on certain policies to allow trade. And we're not saying that trade is evil or trade should not happen or occur. We agree that it should, but we do call for a balance in that. And in only the individual governments of countries will know what is required for their citizens. It will be difficult to have that captured multilaterally. And there have been attempts to do that in the multilateral space, which the Africa Group is actually saying is not working. So this usually happens through things like flexibilities. And a good example is the TRIPS agreement, which is the agreement on trade-related intellectual property rights. The TRIPS agreement has flexibilities for specifically developing and least developed countries. And a good example is what happened during the COVID-19 pandemic, and we are still in a pandemic, but what happened with regards to access to vaccines. I think that conversation is still underway at the WTO to have access to those vaccines for least developed and developing countries. Now, if at the multilateral level, there is a conversation like that going on, what happens on the bilateral level where bargaining power is reduced because you do not have a group coming together to negotiate? It means that negotiation becomes even more difficult, and the possibility of policy space, meaning the ability of a country to determine for itself the laws and regulations that it will have that best suit its interests, and particularly best suit the public interest, are eroded. So that's exactly what I was mentioning when I talked about the analysis of the comments. If we have an industry lobby group saying that they do not like the Data Protection Act in Kenya, and that this STIP or the STIP, this investment partnership agreement, should include provisions that would override domestic legislation in Kenya, to me, that is a clear erosion of the policy space in Kenya. And to do that for trade, as Dr. Pologendi had said earlier, is really ridiculous. And also that means it undermines the very constitution that holds the country together. So the implications are huge for the reduction of policy space, especially in the area of digital trade. It is a new area. We have just started regulating it. We have just started putting up legal frameworks that could probably address the issues that are still yet to come up and can continue to come up. If we enter into an agreement where industry is leading where policy should go, that means that the public interest is no longer the focus. And obviously, citizens' rights might suffer injury. It's important to note that we don't have to always copy what is happening in the West. We can definitely come up with our own policies and stick to them because we understand the context. What happens during such negotiations of bilateral agreements is that there's a lack of public participation. So if trade negotiators from the Kenyan side, for example, are used to negotiating around trade in goods, but do not really understand the implications of acquiescing to some provisions in digital trade, for example, then that would definitely lead to an erosion of the policy space in that area and would hinder the country from further development. Because if countries are moving towards the digital space, then we also need to consider how that digital space will look for us. While we are still wondering about AGOA and trade in goods, we need to also think to the future towards what, for example, artificial intelligence would mean for the country, and how we can allow that space to be innovative, but also not to erode human rights.
Thank you,
Yeah,
Dr. Yeah, go ahead, Dr. Handy.
yeah, it's true because the best example is when COVID struck in 2020. European Union and a few other countries were able to use the GATT exceptions, particularly Article 11 on quantitative restrictions. And they said you are not going to export protective gears, you name them, the materials they needed for combating certain measures, which became a big problem for those developing countries which needed supplies. And there was a huge uproar. US also wanted to do this, but backed off. Now, when it comes to TRIPS, and India and South Africa presented an agenda that, hey, look, we need to diversify production. We need to make sure that intellectual property is not a barrier for us to develop the necessary technology, including medicines, vaccines, therapeutics, you name them, medical products. The same governments now said, wait a minute, let's talk about it. And only in 2022, people died. That they agreed, okay, now you can waive or you can have certain relaxed provisions for vaccines, you know. We are not going to insist on certain standards for vaccines. Then they said, okay, no, but we are not going to talk about therapeutics and diagnostics. And up to today, we see the governments having the vaccines, but they cannot cure or they can't take the same advantage to therapeutics or even diagnostics. So we don't even know who will how you will diagnose and do those things. So you can see already there's a bit of a bias in terms of how developing countries are allowed to use flexibilities which actually exist in the trade agreement under TRIPS. Even negotiations which are supposed to be on basis of public imagine long discussions, and sometimes they don't, even by the time they're granted, they don't serve the purpose which was supposed to be there in the first place. So you see the way the industry, when allowed to dictate the agenda of the government, can really even tie down a government in developing world. So that because WTO is consensus based, if one country says no, same approach can also be cascaded down to now bilateral agreements, because for many years the US has pushed for higher standards of protection. They've always looked at multilateral agreements as a base to build on. Okay, so they say processes across all areas of technologies. Then they will use that now to build on higher commitments. And the same thing will happen also for now the digital rights. They will look at whatever they want, and they will make sure that they use whichever platform is available. Sadly, they're moving away from multilateral institutions because they don't have the numbers. So the more focus would be on these bilaterals, and then they can negotiate a multilateral treaty out of that. So if Kenya concedes at this level and then other countries concede, then they will have less opposition in the future when they negotiate a multilateral instrument. Thank you.
Yes, I think that the parallels that you're mentioning are really important between what's happening in, around the pharmaceutical space and what's happening in the digital trade space. There is a multilateral or plurilateral negotiation happening at the WTO on e-commerce, the Joint Statement Initiative that is going so far. But I think what we do see over and over is that through these bilateral agreements and regional agreements, there are kind of these coalitions of the willing that are pushed to have certain rules that then get pulled in at a later date. And we're definitely seeing, I think, playing out in the international spheres, different approaches. The US big tech companies have a very deregulatory approach. There's the European Commission that is, trying to put in kind of more privacy focused legislation. We also see, Japan's data free flow with trust initiative. So there are various, I think there's a race to some extent to lock in certain sets of rules and around the big tech space. And I think the Kenya STIP is part of that, discussion. Another thing I wanted to ask both of you is one of the elephants in the room with respect to these negotiations is that one country in Africa, especially in the East African community, is being singled out for this bilateral negotiation. And I know that there definitely have been reactions from the East African community with the proposed US-Kenya free trade agreement and implications for this proposed STIP and what the conversation is like around at the regional level and at the continental level around this US-Kenya bilateral talks.
Yeah, I can go. So first of all, you reckon that Kenya is a member of the ESC, and what that means is that they have a protocol which essentially makes the ESC custom union. And under the protocol, I think it's Article 37, they're required to notify the Secretary General of any such negotiations which may give preference in terms of import duty-free to a third party who is not a member of the community. Why? Because a custom union will be losing money or whatever it is that will happen. It will distort trade to some extent. Now, the question has always been, at what time do you do this? Kenya has always said, we are still preparing negotiations. We don't have a text. The Congress has not okayed, especially in the context of the US FTA treaty. And it says that as soon as we have Congress okay it, or we have a text that we can talk about, then we will be able to notify. But now we are just preparing to do that. So the same also is being required from the African level continent. The African Continental Free Trade Area also has certain expectation to its members. But the long and short of all this is that the trade within the African continent, and particularly within ESC, is much more important than even the trade with the US. And Kenya should be very aware about that fact, so that putting the relationship with other East African community countries in jeopardy for the sake of the relationship with the US is simply not, it doesn't make sense at all. But I would be much more concerned if Uganda or Tanzania said, hey, you cannot trade with us anymore because of the game, and you no longer listen to us. So even as the negotiations continue, I think whoever is in the lead, my very good friend, should be able to think hard and deep and do at least what the treaty, the protocol requires. Have the rest involved. I know there's that small issue, the rest of the countries, but still it is Kenya who will lose if the other countries stop collaborating with them. Thank you.
Yes, I definitely agree with Dr. Paul Ogendi. I think the sentiments that came out from the region when we first learned about the US-Kenya FTA was that we were all learning at the same time that something like this was happening. And though there might be technical processes that need to be considered, and definitely we know that agreements are negotiated in secret, at least a notification to the community is something that should have been considered even as a courtesy, but more importantly, because of the trade that goes on between the three countries and broader within the continent. It's also interesting that at the same time we had the African Continental Free Trade Agreement being negotiated, and this agreement has elements of a digital trade protocol and definitely has an intellectual property protocol as well. So if Kenya is negotiating in these two forums at the same time, it would be interesting to know if they're speaking with the same voice in different forums, because obviously the bargaining power is different in the different forums. And of course, because we don't know what is in the text, it's difficult to say that that is actually happening. But we hope that they are sticking to one game plan that is fair across the board. Why? Because the US-Kenya FTA, which I call the predecessor to the STIP, really was touted as a model agreement. What does that mean? It meant that whatever was negotiated and agreed between the US and Kenya would be a model for further agreements between the US and other sub-Saharan African countries. So that means that Kenya is not only negotiating for herself, but she was setting a standard for the whole continent. And that really would have been favored if there were conversations that were happening with other countries. It would be unfortunate to set a standard that would be unfair for other LDCs or other countries in general that we have to turn around and continue to trade with. So it's really interesting. That has been an interesting conundrum.
Thank you. It will be very interesting to see how that plays out in the context of these negotiations. As you mentioned, that potentially the STIP could be a potential template for future negotiations in the region. Do you think that African nations would benefit from adopting a regional strategy to counter pressure, such the bilateral negotiations, or particularly the positions that the US big tech companies are pushing in the context of digital trade?
Yeah, so I'm not sure whether it was my question, but I will go first. I think generally, because Africa wants to, through its free trade area, African Continental Free Trade Area, they want to trade with each other, and they want to explore a common rule to protocol, the African Continental Free Trade Area Agreement. It is important that countries, particularly United States, which is, if you ask me, more than 50 countries together, the United States anyway, shows on the rules that they have provided for themselves, so that it does not distort the trade from whatever has been agreed upon in the agreement. Going country by country will usually cause a lot of friction. It will usually cause a lot of problems with the other partners. And eventually it will undermine the objective of the economic integration agenda of the African Union. And if the integration agenda is eroded, we are going back to the same problem we had before, which is divide and rule, and we'll forever be complaining about underdevelopment in the continent. We've tried in the past to collaborate with British, we've collaborated bilaterally in the past with Portugal, depending whether we are Portuguese speaking country or French, if you're Francophone. But all of us are out of that unity. But we've seen in the past bilateral engagement with the superpowers, it really doesn't bring any wealth in the continent.
Dr.
I
Omino,
think
did
you're
you have any
muted.
comments there?
You were muted, Melinda. We
Yes,
didn't
I'm
hear.
sorry. Did you have any comments, Dr. Omino, on that question?
Yes, I think definitely we would gain from, I think that would be my best case scenario, which is, I think, very far off from happening. I think many people would tell me that is what is happening at the African Continental Free Trade Agreement negotiations. My best case scenario is if all African countries came together to negotiate as a bloc, because that's where they are telling us we are headed. Otherwise, why is there an African Continental Free Trade Area agreement? And why is there a digital protocol that all members are meant to be adopting? If we are at that level, then should we not negotiate as a bloc, as a whole continent then, to ensure that whatever is happening at the AFCFTA will then flow into other bilateral agreements? And I think also that gives us a lot of bargaining power and helps us move towards the digital trade era together. So that would be that's, I think, a wonderful strategy. I think we're already failing. We're already failing. So probably what would need to happen is, or what should have happened, or what I would have recommended to happen, is probably a pause in these negotiations to wait until at least the digital trade protocol came out, so that then that would have been a good basis to use for negotiation of the STIP.
And just to add that at the WTO, we're already seeing a move towards cooperation. There's African group, there's all manner of groups which are working in solidarity and agreeing first before going to the main table. So if that is already happening at the WTO, I don't see why it cannot happen back at home.
Yes, thank you. So we have a question in the chat, and if others have questions, please give them as we're getting close to the end of this important discussion. We have a question about getting a reading of Kenya's private sector feelings and attitudes toward the negotiations. There is a question about Kenya's agricultural sector. I know that the focus of this webinar is more on the digital, but if you have any information about that as well, do either of you would like to respond to that?
Yeah, let me jump in about getting a reading of Kenya's private sector feelings. I think this is really one of my major gripes about how we go about negotiation from the Kenyan side. It would have been wonderful if there was some aspect of public participation that happened earlier on, such as what has happened in the US. We haven't really seen that happening in the Kenyan space. If it's happened or happening, it is really under wraps. So probably there has been certain sectors that have access to government officials and have shared what they would want, but that has not been made public. What I can say is that most of the industry, if you look at in relation to digital trade, most of the industry's interests are not really purely Kenyan. So some of them would be captured by what big tech in the US is asking, because they are sort of paternalized or fraternized by a big tech. It was also interesting to see the American Chamber of Commerce, the Kenyan chapter, submit comments to the US Congress. And they were really aligning mostly with what other big tech industries were saying. So I think that really pointed to me where industry is going. It needs a further analysis of what is Kenyan private sector industry. Who are they and where do their interests lie? Are they purely Kenyan, or are they other interests that are based within the Kenyan space? I think we have to be careful to ask ourselves that question. In terms of agriculture, I do know that under the US-Kenya FTA. There were some comments that were submitted, and mostly the comments from the agricultural sector were surrounding the expiry of AGOA and the access that AGOA gave people to the US market. And we know that AGOA has sort of been, I don't know what to call it, a black hole. It was the whole reason why the Trump administration said it was having this discussion of the US-Kenya FTA in the first place. And it's what the previous administration in Kenya used as a justification for entering into negotiations, that AGOA was ending in 2025, and there was no idea if it was going to be renewed. So most agricultural industry within Kenya really were for the agreement because the fear was that AGOA was ending and they wanted to continue to have access. And this agreement, the FTA, was touted to be a way to continue access. But so many conversations since then are pointing towards the renewal of AGOA. So it doesn't then make sense. If you have AGOA continuing, should you then have another FTA happening at the same time? Yeah, so that's what, those would be my answers to those two questions.
Yeah, and for me, I think this has always been a philosophical question for me. Public participation alone is not enough. Let me put it start from there. There's always been a conflict between public interest and human rights. I think human rights also should be part and parcel of the discussion. So when I say human rights, I'm talking about privacy rights, talked about before, the right of farmers, in Kenya, because you could hear the private sector aligning itself with the requirements of the big pharma as part of public participation process. But if it violates the human rights of the small farmers, indigenous, those who really do the subsistence farming and violate privacy rights of consumers and digital services and all these kind of things, then that becomes a different conversation. So I think the approach of the government should be public participation or public interest plus human rights. And human rights will be the last defender of the right thing to do. Because we've seen many instances whereby the private sector really, which is a big player in trade, does not align with some of the things we're saying here. So the only thing that they may listen to is human rights, that, hey, we're talking about your privacy. This is not negotiable. We're talking about the rights of indigenous farmers and all these kind of things, so that we don't lose focus on the most important things. So yes, there's need to listen to everyone, but also make sure that we don't leave the weak, which is the focus of human rights, behind. Thank you.
Thank you. I mean, I think that's a wonderful way to kind of begin to close this important and timely briefing. I want to underline what Dr. Omino said about the use of the potential expiry of AGOA being used kind of as this boogeyman to push for a bilateral agreement. Just again, AGOA has been renewed in a bipartisan fashion over and over. We don't have any reason to believe that AGOA would expire, and so I think that should be a message that is clear, kind of in the context of these negotiations. And we are at the hour, but I don't know if either of you have any kind of closing comments around recommendations that you would have for policymakers and CSOs who care about data protection and digital rights. I mean, I think what you already said, Dr. Ogendi, is around human rights is clear. But if you have any closing comments, we would welcome them.
Yeah. So I think. Sorry. Okay. Can I go first?
Sorry. Yes. Oh, thank you. I'll go first. Thank you so much, Dr. Ogendi.
I think like I
sorry,
said,
we couldn't
the
hear
human
you.
rights also.
Sorry, you're breaking up a little bit. Okay, maybe try again. You broke up a little. I'm sorry, we're
Okay.
having trouble hearing you. So maybe I'll go ahead, Dr. Omino.
Okay, I think that negotiators need to try and do some public participation. I'm saying that in the context that I believe public participation will capture those CSOs or those advocates and activists who will talk about human rights. I think that definitely it would be interesting to also know who's negotiating. I remember when we were looking at the US-Kenya FTA, it was so difficult to know who was negotiating on behalf of Kenya. It was people from various government bodies that had various interests in mind, and we didn't really know who would talk, for example, on the aspect of digital trade, if they understood it well enough to be able to negotiate it at such a level. Now, at least we know who is leading the negotiations for the US-Kenya STIP, which is a great leap forward. And we do know that it's somebody who has a great wealth of experience in trade-related matters. But for everybody, digital trade is a new concept. So it would be great if they did call for public participation or for memoranda so that they could sort of hear from different experts in the field. That's the first thing that I would say. For the rest of us, maybe we shouldn't wait for public participation. We should just start talking, which is what some of us have started to do, and create awareness. And it doesn't have to be technical conversation, because people shy away when they hear the terms international trade because they believe it's so technical. It really boils down, as Dr. Polo Gendi has been saying, to your rights. So if you think about your rights online, if you think about your data and where it's going and how you want it to go, if you think about all those dystopian movies that are out there and how personal identities are used or manipulated, that is you talking about something and just asking questions and saying, what would happen if this scenario occurs? Or for the youth who are all moving online for their businesses, if you think about how would that affect your business? Especially if you think about digital services tax, which is another element that could be affected by this agreement. So let's just start talking, but I would hope the negotiators would also put out a call. Finally, I hope Parliament, which will be the saving grace, the Kenyan Parliament, because usually these agreements land in Parliament for discussion before adoption. I hope that Parliament is going to start to inform itself about these technical areas so that they will be ready to actually debate the matter properly, because they are our last bastion of hope.
Thank you.
Yeah, so for me, I think I will start with the promise which was given by the Biden administration. It is no longer efficiency, but also consumers and workers' rights and environment. So we need to see a different approach, because what we are seeing is the same old framework for negotiations. You cannot promise one thing and still do your processes the same way. That is number one. Number two, like I said, human rights impact assessment should actually be part of the process. In fact, my PhD has always insisted that all this procedure in trade, there's a big role human rights should play, because usually the negotiators are using different tools, including demand and supply, efficiency, and all that, but they never really think about human rights. And the truth is that human rights is part and parcel of trade. And human rights impact assessment can help you identify violations before they happen. So even issues of privacy we are talking about here, if you conduct an impact assessment, and under the Privacy Act, it is required, you must conduct an impact assessment. So you ask yourself, because this is something that is going to fundamentally alter your rights and freedoms. So it is something that can be enforced even in the law as we speak today. If you have such a process which are going on and you're not subjecting it to an impact assessment, that would be a big problem. And lastly, I just want to remind my beloved country, Kenya, that Africa and ESC, East African Community, is a very important partner. do not ignore them. Do not feel better that you have been chosen, because the trade between you and Africa and ESA is much more important. And therefore, involving not just the public in Kenya, but also the other countries outside in the continent is part of, I think, the broader public participation. Ask them what they feel about that and all these kind of things, and you'll get a better deal than ignoring them and thinking that you know better in this process. So that is my parting shot. Thank you.
Well, thank you so very much. This was an extremely rich discussion based on very few details that we have so far. So I think we have there's a lot to watch. As we mentioned, we expect the textual based rounds of negotiations potentially starting as soon as next month. We'll see on these negotiations. And I think the recommendations about more public participation and transparency are key as we really dig in to hopefully have a different type of model and to move forward with extreme caution around some of these issues around digital rights and data protection and holding big tech companies accountable will be extremely important. And just to, once again, I put in the chat a couple of times the excellent website that Dr. Omino's team and at CIPIT have put together around the US-Kenya STIP with current analysis as well, and there will be some future reports going there as well, and so it will be a great resource, I think, for folks going forward. And thank you all for joining us. We really appreciate coming together, and I'm sure this will be just the beginning of future conversations on this important topic. So thank you so much.